everyone. I'm Allie Bushelli, and I'm a junior partner here at King Law Offices.
And I'm Martie Wallace. I'm also a junior partner here at King Law Offices.
And what we wanted to bring up as a topic today is the general basic differences between a will and a trust here in the state of North Carolina, because that's a common question we get when we're talking about setting up an estate plan for the first time. Which is better, a will or a trust? Some people come to us and say they need a trust, and it might not be the best option.
Right. Wills, typically, when you think of estate planning, you think last will and testament. In one of our previous videos, we talked about it's not a living will. A last will and testament is really that, your last thing that you're saying and how you want to give away your property that you had when you were living. And it is typically not a private document, and it's getting even less private as we go along. And I'm happy about this, but North Carolina is going to e-file, and most of us attorneys are happy with that. Some attorneys are not, but I am.
Me too.
It opens up our practice area, especially in wills, trusts, and estates.
Right.
So much.
It really does.
But now anyone can look up the will once it's been filed at the courthouse from the comfort of their own home.
Right. You have a laptop and you get on the North Carolina eCourts portal. And if it's been probated, which again is the formal process of the clerk of court in North Carolina saying this is the valid last will and testament of the person who passed away, and therefore their property is going to be distributed under that will. Probate, you hear people say, is the entire process. Legal definition is just that one piece, but we will even say it in the process of the entire estate administration. But Martie's right. That will becomes public record. It's still public record now in North Carolina, but it used to be you had to physically go to a courthouse and request a copy. They'd provide it to you, but you'd have to request a copy. Now with e-filing, you can go to the eCourts portal and just pull it up, and you got someone's name, and you can find their will. And that's scary for a lot of people.
Mm-hmm. And it's also incentive, if you don't want that for your kids, to have to probate. I'm using it incorrectly.
No, it's okay.
Well, you would probate the will, but to perform the estate administration, which is also public. What you're doing with the estate administration is public and filed. And again, now you can look most of that up on the portal at NC Courts. But a trust, on the other hand, is private, and it's a contract between you as the person writing the trust, the settlor, and this is a revocable living trust. Irrevocable trusts are for another day. They're much more complex, a little more involved.
Right. And so Martie's right. Today, just for really brief, we're talking about revocable living trust or living trust or revocable trust. And they are what Martie said, they're a contract, but it's an estate planning tool. It's something to pool assets. And so you were talking about how it's really set up.
Yes, that it goes into effect right then, where a will is an executory contract where there's a triggering event that causes its time where it comes alive, and that would be at the death of the testator, the person who wrote the will. So if you want to have your kids not have to necessarily go through probate or estate administration that's public through the court basically oversees it, you would sometimes, well, I guess you would want a trust, but the trick with that is you need to make sure that you have all of your assets that have a title to be named in the trust, or to have a beneficiary associated with them, or joint with rights of survivorship.
Right. We've got a lot of wars there, and a big thing is also, especially for the state of North Carolina, DMV gets very testy with vehicles in the name of a trust. And so usually you keep that in your own name. With a trust, you have what's called a pour over will. So you still have a last will and testament, but you say, okay, anything that didn't get put into the trust first, we're going to put this over into the trust after I pass away. There's also some other benefits to a trust versus a will. You have a little bit more flexibility, not just privacy, but flexibility. When you're talking about things that a clerk is going to have to audit, which is the process of them saying whether or not they're going to approve transactions. They have to approve what you've done in the estate administration process. If you've got something that's, I don't want to say complex, but more difficult, and it involves a lot of cooperation. I've had a client who put a down payment on their child's house. They just decided, okay, I've got this chunk of money, I'm going to put a down payment, but I want my other child to be compensated for that. But I want the market changes to also be accounted into it. So I want I want there to be this calculation for, okay, how much would that down payment, let's say I put $200,000 down, how much would that down payment um, inflate between the time I made it and the time I pass away, and the distributions have to be made. When you put that into a will, the clerk's office is going to look at me and Marty a little funny and be like, how are we supposed to calculate this? What we need hard numbers. And so you're kind of put into a box. When you've got a trust, you've got more flexibility in, okay, whoever the trustee is going to sit down and be like, okay, I'm just going to put $200,000 into the inflation calculator online, and we're going to see how much it would be worth today, and that's your distribution. And you have more ability to do that upon agreement. So if both your kids get along, which a lot of times they will with a trust versus estate administration, then okay, you have that number, you can do it, and no one's overseeing what you're doing. No one's, redlining what you're doing. Beneficiaries redline each other. But if there's mutual trust and respect there, you don't have to worry about too much.
Right. And with simple words, trustee discretion, boom, you're good to go.
Right. And so we just use the word trustee. And so that's probably like, okay, what does that actually mean? When you have a trustee, that's the person who is responsible for making sure that all of the things you wrote down actually happen. So if you said, my daughter Becky is to get my wedding set, your trustee, even if your trustee is not Becky, is responsible for making sure the wedding set, one, doesn't get buried with you. and two,
Yeah.
and two, actually goes to Becky. And the trustee is not on a timeline from the court, isn't on a timeline from creditors, isn't on anyone's, radar except everyone that's involved in the trust. So if everyone's good and it's time to give Becky the wedding set, go ahead and give Becky the wedding set.
Yeah, it works out well, for the most part, perfectly. We see when it doesn't work out perfectly, but a lot of times we can handle that, and then we say, listen, everybody just needs to work this out. If we've got two attorneys, the other attorney will call the other attorney. We will call opposing counsel. Say, I think we can work this out. And oftentimes we can, because as long as everyone's being reasonable. Sometimes we can't, but most of the time we can.
Right.
Another thing with having a trustee is that when the trustee takes the possession of the property, then he or she will follow the rules, sometimes called provisions, within the trust. When that is very nice is when you have a person, the settlor, the person who wrote the trust, when they have real property that's not in North Carolina, that's in other states. What that does, it saves a boatload of money that we don't have to do an ancillary administration in another state. Because when we do them here, and what that means is if you have somebody, let's say for our purposes here in North Carolina, we have a person who was a resident of South Carolina, lived in South Carolina, died in South Carolina, but had some North Carolina property. They would start the estate administration in South Carolina, get that will probated in South Carolina. We get an exemplified copy of that here, and then we do an ancillary administration here, and we charge a fee for that. Well, if in South Carolina they had a trust that said what to do with it, and they named this North Carolina property in the name of the South Carolina trust, no problem. That trustee can take care of everything.
Mm-hmm. The trustee has the authority. The property's already in the name of the trust, or if for whatever reason the property didn't get put into the name of the trust, then the property does still have to go through the estate administration process. And so when we talk about things like, okay, we got to make sure that this trust has the assets pulled into it, we call it trust funding.
Mm-hmm.
So here at King Law, we do provide trust funding instructions for our clients, and we go through them and make sure everyone understands what that means. And really, it's putting everything in the name of the trust. And when you have a revocable living trust like this, you don't need a new tax ID. It doesn't have its own entity status. It does and it doesn't. It's very odd. The IRS is just going to treat it as your property. A big disclaimer I think Martie and I should make is this is not for Medicaid asset protection. That's a very different type of vehicle. This is only for estate planning purposes. So if you need to make provisions for Medicaid planning, that is definitely something that you would need to have a consultation with. I don't even think we could do a video under 5 hours to discuss everything with Medicaid planning. That is something you want to definitely have a consultation with an attorney. Martie and I do Medicaid planning ourselves as well as our entire team. So when you're talking about a revocable living trust, you can put all of your bank accounts, let's say you have some bank accounts, in the name of the trust without having to reopen accounts, closing and reopening. You just change the name because it's still associated with your social security number.
Mm-hmm. And you don't even have to have on your checks the trust name. They will actually, banks are okay with just using your regular name, so you don't have to spell out the giant trust. Or you can even list the trust as a beneficiary on the checking account. There's so many ways. That's why meeting with an attorney and not attempting a do-it-yourself trust is really the best way to go, because you would hate to have this false sense of security that everything is going to go the way you want it because you got the trust offline or online, and you got it from not Home Depot,
Office Depot or Staples. Yeah.
Actually, I can't think of one that was done correctly that was given to me, and I kind of cringe. I don't want to, because I don't want to hurt someone's feelings or destroy their day, because typically the person who made the trust is in heaven and we can't reach them.
Right. And the big thing with trust is you want to curate to what you want to see happen. A lot of the services are going to have just provisions written out that you may not like and don't know how to go about getting rid of, making it what you want it to be. There are, in our template trust agreements, we have all of the trustee authority written out. Everything that someone could do under the state of North Carolina as a trustee is written out as a authority. But if our client doesn't really want that authority vested in their trustee, we can delete it out. So you can't necessarily do that with these online or Office Max type documents. Also, the execution is very important. And if you're not sure about funding, unless you watch this video, you wouldn't know you needed to fund your trust necessarily, or that you needed to put anything in the name of it.
A trust that's not funded is not a trust. That's the magic thing, is you need to fund it. And when people have real property, I always like to just fund it right there at the signing. Let's sign a deed, a quitclaim deed over into the trust. But don't just go doing that on your own, because there's some things that we would need to talk about. The assessments of the property, those you're conveying it to a new
owner, basically.
It basically is. Even though it stays with you, it's still a new owner because it's the trustee of the trust. And sometimes I've seen it where if the property, this happened where the property that we were going to fund it with was actually in South Carolina. And in South Carolina, at this certain beach, if you changed the ownership value of it, it can go, because they would reassess it instead of doing it at the normal time. Well, the property value had jumped so high. I told them to check that out to make sure that it was not going to jump so high as to cause them heartburn when they got their next tax bill, because at the beach in South Carolina, you pay a second property tax that is so much higher. But I at that particular beach, they could only go up 15% was the cap on that. But if they hadn't had an attorney saying, hold up, you need to double check that now is the time to do that, where we might have something else to do differently, because we also have offices in South Carolina where we have licensed attorneys, which is really nice. I can call them up, say, what do we do here? So if you do have properties in other states, we call or get in touch with another attorney to help us facilitate this, and it to where it's just about seamless. I've done that with Florida. We've got an office going in Tennessee. I've done one in Georgia with another attorney. It's not hard at all. They know exactly what we're doing.
Right. And it's easier for an attorney consult sometimes just to be like, okay, hey, we need this document. And we also do attorney to attorney consults free of charge. So if we get a call from an attorney in another state that's not with our firm that says, well, I need assistance for my clients to transfer property into a trust that I created here in Arizona, as an example. Okay, well, we'll have that consultation for free. We'll quote for the services. And usually that attorney is great in facilitating, getting documents and making sure signing happens and things like of that nature. Also, a reason to not put a property in a trust is tax advantages. There are certain things in North Carolina that people get tax breaks for based on age, prior career. I know there's some first responder discounts in some counties for property taxes and things like that. So we don't want to disadvantage clients by saying, hey, let's put this property into a trust when they have so many more tax advantages keeping it out of the name of the trust. There are other estate planning deed options that can be explored. But again, when you do things, do it yourself, there's a lot of things that can happen that you just don't anticipate. And no one was malicious. No one means any harm. It just happens. Unfortunately.
Yeah, and a lot of times, in that case, that's a fixable thing. We can just pull it out of the trust and put it back into that person's name. Would that be correct? Does that still hurt it? I don't know.
I'm not 100% sure, and it's going to depend on the county. Is it once it's transferred, is someone grandfathered into something? Is it, it's just the ownership, and so it'll go back? That's something that your attorney can curate for you.
So maybe it would, maybe it wouldn't be able to be cured once it's done. So another reason to consult with an attorney first. I've seen, like, especially in the probate area, I know we're not talking about that, but I've had people open up probate. It's fairly simple to open up an estate. What's not simple is to carry it through to the end. In North Carolina, it's not that simple. And then once you open up an estate, you can't stop that train. And there's sometimes people will, and we'll talk about it in future episodes, but you could lose an entire house by doing that, where if you had not opened up an estate, you'd be fine.
Right. And definitely consider before, if your loved one has passed away and you believe it's time to open up an estate, consult with an attorney prior to, because one, the attorney will be able to offer you services to represent you as personal representative or whoever has been named as the executor in a will, or who would serve if there was no will, can walk you through the process a lot easier. For estate administration, North Carolina is very form driven. And so you would think pulling the forms online or getting them from the clerk's office, heck yeah, I can do this. That's not going to be a problem. But those forms are about as clear as mud. Martie, I don't know how many estates it took you to be comfortable with the forms, but it probably took me a good 3 or 4 going through the process to know, okay, this gets listed here, this gets listed here. I don't have to list that until, 3 months down the line, and then this gets listed in this way, but I need this value, not that value.
I remember looking at the AOC forms, which is what they're called, for the first time, thinking, yeah, easy peasy, lemon squeezy. I think it was exactly what went through my head. And I'm doing it. It's going to be great. I file it and I get a phone call. So she sent me back to redo it. And I'm like, how embarrassing. Oh my gosh, this is terrible. I'm an attorney. And then I kind of wanted to call my law professor in law school and ask him why he didn't talk about the North Carolina AOC forms.
You went to law school in Virginia.
I know. But I still think that, for as much as I paid, I should still get that education. But I didn't. So then I go through it. Then finally I get it down, Allie. And I know you know this. Then I start practicing in other counties because we're spread out and I enjoy, picking up other counties. It's great. Well, apparently every county does it a little bit different. So that was fun. So now what I do is, matter of fact, I just picked up a Mitchell County,
Mm-hmm.
which is far away from me. I tend to practice out of Mecklenburg County, but I have them everywhere, just like Allie does. And before I filled out the AOC form, I called the clerk. And do you know what? That clerk was so sweet. And it was probably a deputy clerk. Thank you so much for asking, because that makes our job so much easier. And that's the other thing I think that King Law does really well is we treat our clerks very well. I know I do bake some cookies here and there and bring them.
I
Is
do my
that
best.
bribery? I don't know, but we're not going to talk about it if
It,
it is. And we love our clerks. So if any of the clerks are listening, we love you very much and thank you for everything you do for us.
and that's an advantage of hiring an attorney is you do get that relationship with the clerk's office and that advantage of that long standing relationship and then being able to kind of give some information. So clerks cannot give legal advice. And so you go in, they say, we can't give legal advice, go to a lawyer. We're giving you advice. We're giving you legal advice as a client. And then the clerks are saying, hey, we just don't like that in this row. Will you put it down in another row? It's things that are as little as that.
Yes.
But I mean, we've talked about a lot here. The big thing between wills and trusts is you don't know which's best for you until you sit down and talk with an attorney on which is your best option. And that is something that Marty and I do almost every day. We meet with people about, their estate planning options and curate a plan that's going to achieve their goals. So if you would like to schedule a consultation with any of our transactional attorneys, myself and Marty included, you can give us a call at 828-286-3332, and our client services team would be more than happy to assist. If you've got inquiries or would like to see something addressed in another video, you can reach out to us on our social media, Facebook, TikTok, YouTube. I think we're now on Spotify. And we'll be more than happy to help you out and get everything rolling for you. Thank you.
Thank you.